Jonathan Pollard, non-compete and trade secret attorney in downtown Fort Lauderdale, Florida. And I'm going to talk today about Florida non-compete agreements, injunctions, and appeals. The bottom line is that Florida is the most aggressively pro-non-compete state in the entire country. If you are sued in Florida state court for violating a non-compete agreement, you cannot remove the case to federal court, and you are forced to litigate the case in Florida state court. There is a very high likelihood that you will be on the receiving end of an injunction. It doesn't matter how strong your case, it doesn't matter how strong your defenses, how strong your counterclaims, or how weak the plaintiff's affirmative case. Florida is a pro-non-compete jurisdiction, and many state court judges, particularly at the trial court level, misapply the law and routinely issue improvident preliminary injunctions. This is bad news, but this is not a case for despairing. This is not the time to give up, to quit, and throw in the towel, particularly if there is a lot at stake. There's always the possibility of taking an appeal and having the injunction vacated and the case remanded. Unfortunately, many litigants and many lawyers fail to prepare correctly on the front end to preserve the matter and issues and set the record up properly for appeal. So I'm going to go through just 3 very basic considerations that you must take into account if you are headed in to a preliminary injunction hearing on a Florida non-compete agreement. Number 1, get a court reporter. That may seem so basic as to be absurd, but it is a significant problem in the Florida state courts. And I say that as somebody who has a comparative perspective on a number of other jurisdictions. I've been involved in a number of cases in New York and Pennsylvania in particular, and the notion that you would have to be concerned about getting a court reporter for something as important as a preliminary injunction hearing, this is a Florida-specific problem. All of the matters in which I have been involved in Pennsylvania and New York, there is a court reporter there for that hearing, no matter what. There is an official court reporter, a person who is employed by the court whose job is to record these hearings. In the state of Florida, not so. And in fact, I have seen a number of instances in which the plaintiff moving for the preliminary injunction did not bring a court reporter to the hearing. An injunction was subsequently issued. And then because there was no transcript of the hearing, there is no record of what transpired at the hearing, there's no record of the evidence put on at the hearing, and as a result, the court's order granting the injunction is significantly insulated from appeal. In some instances, that lack of a transcript renders it absolutely impossible to appeal the court's order entering the injunction. So the bottom line here is get a court reporter. And even if it is not your motion, even if the other side is moving for the injunction and they are intending to bring a court reporter, get your own court reporter anyway. Because I would not put it past many lawyers, particularly in South Florida, to try and pull a fast one by having an injunction hearing and then preventing an appeal by not bringing a court reporter. So if there's a hearing on a preliminary injunction, if you are the defendant, get your own court reporter. Go to the hearing. If 2 sets of court reporters show up, that's fine. You can send one of them home, but make sure there's a court reporter so you make sure there is a transcript of the proceedings that can be used if you need to take an appeal. Number 2, with respect to evidence that is going to be presented at the hearing. I can assure you, having done this many, many times, the plaintiff will take the stand, will be an officer, a director, an owner, and they will testify almost verbatim from the statute that they have valuable confidential information at issue, that their confidential information is proprietary, that it's so important to the business, that they take steps to protect it, etc. They will testify that they have substantial customer relationships. In fact, we had a case up in the Middle District of Florida, albeit federal court, where there was a witness for the plaintiff who took the stand and referred to their customer relationships as substantial. Nobody would pull the word substantial customer relationships out of thin air. The only reason why you would say that is if you were coached by your attorney to parrot the statute over and over again. But I kid you not, that's what's going to happen. Someone is going to take the stand and talk about how they have substantial customer relationships, special customer relationships. Next, they're probably going to talk about how they made a tremendous investment in your training, education, etc. So you have to be prepared for this line of testimony. How do you deal with this? You have to cross-examine these folks. If someone takes the stand and talks about their valuable confidential corporate information, you have to tear them to shreds. You have to be able to establish that the information is readily available to other competitors in the industry. The information might be confidential to them, but it has no value. The information quickly grows stale. The information can be purchased through commercial mechanisms, i.e., you can go on Google, you can find the database, and you can buy it. Bottom line, you have to rip to shreds any claims that the information is confidential. Same thing with the substantial customer relationship point. If they take the stand and they say, we have these substantial customer relationships, our customer relationships are very special, they're very important to us, you have to tear that apart. You have to establish that the customers at issue do not have exclusive relationships with any one particular company or vendor. You have to establish the customers' identities are readily and publicly available through Google, the Yellow Pages, etc. You have to establish whether or not the customers solicit competitive prices from vendors or, in fact, accept formal bids if there's an open bidding mechanism. You have to establish whether or not the company has a spotless record of service vis-a-vis these customers. Have there been problems? Have there been complaints? Have there been disgruntled customers that have terminated relationships? With respect to extraordinary training, likewise, you have to attack that contention, and you have to establish that this is the same sort of on-the-job training anybody else anywhere in the industry in a comparable position would be receiving. Finally, a word about exhibits. In the context of a preliminary injunction hearing at the beginning of the case, before you have had the opportunity to get into the record, to review these documents, exhibits, etc., the plaintiff may seek to introduce various documents at the hearing that are really voluminous compilations. They're compilations of business records, sales databases, etc. And the rookie lawyer on the defense side of this type of a hearing may say, well, wait a second, this is not fair. This compilation is 100 or 200 or 400 pages long. It's being sprung on me at this hearing, and I haven't had a chance to go through this and figure out whether or not there's anything in here that's objectionable. That's a rookie perspective, and it's a big rookie mistake, and let me explain why. Okay? In this context, you have to be concerned about setting up the record for appeal. And one of the problems is, given how early it is in the case, given how quick and compressed this hearing is, there's not going to be a whole lot of evidence, particularly documentary evidence in the record in many of these cases. And if somebody wants to introduce, if the plaintiff wants to introduce some compilations of various corporate documents, records, databases, etc., you have to go with that. Don't object. Let that stuff come into the record. Why? Well, the bottom line is, if there's something bad in there that hurts your client, it's admissible anyway. It's going to come in as some sort of business record. You're not going to be able to hide it. It's eventually going to see the light of day. On the flip side, there could be something in there good for your client. There could be something in there that helps your client's position, i.e. makes it clear that the customer relationships aren't substantial, that the information isn't confidential, that the training wasn't extraordinary. So on balance, if you feel like you're getting attacked with, voluminous exhibits at a preliminary injunction hearing and you really haven't had you haven't had proper time to review these, parse through them, and find out what's in there, it doesn't matter. Don't object to it. Let it come in. You want that to be part of the record. Why? Because afterward, when you have to take an appeal, you have to go through that record and see what you can use. And on balance, you're better off getting it in, because then at least you have the possibility that it contains some resources that you can use to help you build their case. There are several other considerations here. Specifically, I would note injunction bonds. If you ever find yourself in this context and you've been beaten up in a state court injunction hearing and the hearing's wrapping up and you just can't wait to get out of there, you really have to hold your ground. If something needs to get put in the record, if something needs to get said on the record, then you darn well better say it. And when it comes to the court setting the amount of the injunction bond, do not be afraid to fight tooth and nail for a hefty injunction bond, because practice pointer, there is no remedy for you as the defendant in one of these cases for wrongfully being enjoined with respect to monetary damages. You cannot get money damages for being wrongfully enjoined. Your only remedy for being wrongfully enjoined is recovery against what is called an injunction bond. So if you're ever in this situation, if you find yourself at the end of one of these hearings in state court, Florida, where you are absolutely getting reamed, you need to hang tough. You need to get all your stuff on the record, and when it comes to the injunction bond, you need to fight tooth and nail for a big injunction bond. So that way, if you prove you were improvidently enjoined when you take an appeal, you can come back down and you can file a claim against the injunction bond. The only way you know all this stuff is if you've been involved in dozens of cases like this and hundreds of controversies like this, which I have. Jonathan Pollard, non-compete and trade secret attorney in downtown Fort Lauderdale, Florida. If you have a question about a non-compete case, a non-compete appeal, please feel free to give me a call. I'd be happy to talk. Thanks for watching and have a good day.